Everyone, thank you so much for joining, and I hope you guys are healthy and well. I wanted to kick things off by going over some logistics information for this webinar and then introducing our speaker from LAFLA, Gio Peishi, who will be conducting our training on navigating the expungement process through COVID-19. So this webinar qualifies for 1 hour of CLE credit. Before the training, I circulate the CLE form that must be completed and submitted for credit to be obtained. We'll also be reading off the CLE activity code at the end of this training. If you did not receive the form or the training materials, please email me at ashley.kim@lw.com and I'll arrange for them to be sent to you. Please note that any questions you may have during the training may be submitted via the Q&A function, which can be accessed by clicking on the Q&A button on the menu bar. In the interest of getting through the training, we're going to be addressing any questions that folks have at the very end. So now I'd like to introduce our speaker, Gio. Gio is a staff attorney with the Legal Aid Foundation of Los Angeles. He currently works on Project Impact, a program designed to assist individuals impacted by the criminal justice system with overcoming barriers to employment, housing, and self-sufficiency, with the overall goal of reducing rates of incarceration and recidivism. I've had the pleasure of volunteering with Gio many times and know from firsthand experience what a talented, knowledgeable attorney and advocate he is for LAFLA's clients. So really excited that he's joining us today. So thanks, Gio, for being with us. I'm going to hand over the reins to you.
Hi, thank you for all your hard work in putting this together and setting this up. And I'd also like to thank Latham and Watkins for hosting this. As Ashley mentioned, we've worked with Latham folks in the past and always had good results. So hopefully we can continue that partnership in this capacity now. So yeah, I'll just get into it because we have kind of a lot to go through. Typically it's like an hour and a half training for expungements, but we're trying to cram everything into an hour and then go over some of the COVID considerations. So I'll be speaking quickly, hopefully not too quickly. If it gets too much, just maybe let me know and I can slow down. Okay, so let's get started. So just really quickly, for those of you not familiar with LAFLA, we're a nonprofit community-based organization that provides comprehensive free legal services to low-income individuals in Greater Los Angeles. We serve large communities, so we have 6 main offices located throughout LA County. We run 4 court self-help centers and also run a variety of clinics throughout Los Angeles with different community partners we have. What are the community's legal needs? So these are kind of the project areas we work in. And just a quick plug to Fong Wong, who's our pro bono director, our really active pro bono director. So if you see any project area or legal area that looks of particular interest or something you were looking into maybe getting some knowledge or be able to work on, definitely reach out because we're always looking for pro bono partnerships on different cases in all our practice areas. So yeah, just a quick look at some of the work we do here at LAFLA. Just really quickly go over some of our volunteer roles and responsibilities. These are questions and concerns people usually have when they volunteer with us. So kind of the big one you're covered by LAFLA is malpractice insurance. Everything we do in terms of our expungement clinics are in pro per, so your name doesn't go on anything. It's all the client's information. And then LAFLA handles the filing and the proof of service and things like that. So yeah, it's not too stressful. I don't know why that one does that. That's the only one that's going to do that, thank God. So anyways, a roadmap of what the training is going to look like. I'm going to go over a little bit about incarceration rates. Then we're going to go into kind of the nuts and bolts of expungement and the laws, the penal codes that you're going to be preparing petitions and filing under. Then if we have time, I'll kind of quickly move through the expungement adjacent areas, which are the reductions, so felony and misdemeanor reductions. Then we'll go through how to read a docket or rap sheet, which is what clients bring in that have their case information that you need to read to be able to take out the pertinent information. And then kind of lastly, some of the coronavirus, the COVID-19 considerations. So maybe some barriers that clients are facing or that we're facing when interacting with clients, how we're going around the court closures and things like that. Okay, reentry by the numbers, incarceration rates, criminal records, and employment. So for those of you who don't know, the United States of America incarcerates a heck of a lot of people. We're #1 in that regard, so largest prison population in the world. It also breaks down kind of unfortunately on racial and gender lines. So as you can see from this chart, folks of color and women of color are statistically much likely to be serving time in prison. And then kind of what sometimes is an aside for folks when they're talking about the criminal justice system is what does it look like when somebody's coming out, when they're kind of re-entering or reintegrating into society. And something that doesn't get talked about all that often is all the barriers that folks with criminal justice involvement potentially face when they're coming out and attempting to reintegrate. So some of the common legal barriers are accessing employment opportunities, housing, reunifying with family and children. Some of the parole and probation conditions can be pretty onerous. Obtaining professional licenses, student loans. So yeah, I think the Harvard Law or Stanford, I can't remember who just did a really big kind of study of all the laws surrounding criminal records and found that there were 48,000 distinct federal, state, and local laws that limit, discriminate against people with records. So it's particularly telling when you're looking at things like not only that we incarcerate a lot of people, but that they have a really high recidivism rate. So I think it's someplace around 2/3 or 65% of folks with a record within 3 years end up back in the system, either arrested or convicted of another charge. So really high rates of recidivism, and kind of the main thing, or one of the main things that they found helps lower that is getting someone employment. So someone with a job cuts that recidivism rate in third just by being employed. So that's kind of where expungements come into effect is to help ameliorate some of these post-conviction barriers that exist for folks who have records. And kind of as an aside, it's nice that this area, this reentry area, seems to have one of the few areas that has bipartisan support. So kind of both sides of the aisle recognize that you can't lock up this incredibly high amount of people and then put them back out in society and make things that much more difficult for them to be able to get jobs and find housing and be productive members of society. And it costs $60,000 to incarcerate somebody in the state of California. So it makes economic sense, right, to make that transition a little bit easier and provide services that can help that transition move a little bit more smoothly. Okay, so this plays into what is an expungement, the scope of the remedy, why this work is important, why this is potentially so meaningful for clients, meaningful and helpful for clients. So an expungement exactly is considered dismissal. So it sets aside or dismisses the criminal convictions under the Penal Code 12034, which is the code that the expungements are going to be filing under. It doesn't seal or purge or destroy the record of the case. California doesn't really have a sealing mechanism. You can seal arrests, but a conviction you can't really seal, so it doesn't really destroy anything completely, but we'll get into what it does in a little bit. And it only dismisses the specific conviction you are filing a petition for. So if a client has multiple convictions, you'd be filing an expungement petition for each conviction. And then, yeah, kind of more importantly, what is the effect of an expungement? It can potentially help client obtain employment. It modifies what government employers can see on background checks. It can improve the likelihood of obtaining a professional license and can assist with government funding housing applications. So kind of the real clear benefit of expungement is we'll remove that conviction from a private background check. So if an individual is applying to work at like Starbucks or Target or something like that and have that case expunged, it would no longer be showing up on the background check. They could legally answer no to the question on an employment application, in almost all circumstances, that no, I've never had a conviction. So it can be really helpful for helping clients get their foot in their door with job applications, and then eventually obtaining that job. And an expunged conviction will still show up, though, if they're applying to work in the public sector. So like a government job, if they're applying to work at a school, bus driver, hospitals or things like that are required to run background checks by law. They'll still do what's called a live scan. So they'll run their fingerprints and they'll get a DOJ rap sheet. And the expunged conviction will still show up, but now we'll have a line next to it saying it's been set aside and dismissed pursuant to 1203(4). And then the legal landscape is kind of changing for the better in terms of what employers can then utilize in terms of expunged convictions. So even the folks that still see it, there are certain instances, and that's expanding, where it can't be the only reason to deny someone a job. So they can't have like a blanket ban on a conviction type or something like that. They need to do a holistic analysis and really look into the circumstances surrounding conviction at that point. Some of the limitations with dismissal, I kind of went over this really quickly, but jobs that require a live scan background, they'll still see the convictions. So those are your public sector jobs, those jobs that are required to run background checks by law, those occupational licenses, which are more pervasive than people think, right? So like, you know, to be a barber, you need a license from a licensing agency. So that comes up quite often. It doesn't remove a requirement to register as a sex offender. It doesn't mitigate immigration consequences, except in really limited circumstances that I'll go over. It still counts as a strike. It doesn't reinstate driving privileges, and it doesn't restore gun rights. So there are some limitations to it. It doesn't remove the conviction entirely, so the courts can still utilize it as a prior when someone was to pick up another case. The expunged conviction still is there. It counts as a prior. It can be used for enhancement, so it doesn't remove it from law enforcement or court purposes. So kind of the big ones are housing, student loans, and employment. Okay, and then moving into the actual expungement eligibility requirements. And I think it's helpful to keep this in your head kind of separate as a two-part process. So for every expungement code you're going to be filing under, you need to figure out first if the petitioner themselves is going to be eligible, and then if the conviction is going to be eligible. So yeah, two-prong test. I think it's helpful to keep those separate in your head. In order to have an eligible petitioner, the person applying for or petitioning a court for expungement cannot be serving a sentence for any offense. They can't be charged with the commission of any offense, be on probation for any offense, or have any outstanding warrant. So this is true just kind of across the board, because this is like the preliminary prong you have to get over. If, let's say, someone had some convictions from 2003 or 2005 that they wanted to get expunged, and that case was closed, it was over, they served their sentence or whatever, so they want a petition to have that expunged. If, let's say, they got a DUI in 2018 and were still on probation for that, they would have to wait until their probation terminated on their current case to even be eligible to go back and petition for those earlier cases. So they can't be serving a sentence of any kind currently to be able to file for any other case, even the cases in their past. So that's the first prong. You have to make sure you have an eligible petitioner. And then the next thing you want to know, is the conviction going to be eligible for expungement? So convictions that are going to be eligible are misdemeanors and infractions, and then felonies with jail or probation. The red flag is prison time, and this used to be kind of like a hard and fast rule. If you saw a conviction with prison time, unfortunately, folks were not going to be eligible for expungement, but there's some exceptions to this now. So it's still kind of the closest thing to the red flag. And I think something that's maybe not intuitive, right, is really what matters is the sentence they got, and not the actual conviction. There are some convictions listed there that are statutorily not eligible for relief, but really what you're looking for is what kind of sentence did they got on it, because if they served time in state prison, it might not be eligible unless it fits into one of these exceptions. So I think kind of one of the early mistakes folks who are just getting started out in expungement make is they get caught up in what the charge was. And I don't know if it sounds kind of heinous or it says felony or something like that. There's kind of this trepidation that, oh, this probably is not eligible. But really what you're looking for is the sentence they got. And maybe I'll use this time because I forget to do this, but I know sometimes folks don't have a whole lot of involvement with the criminal justice system. So just go over really quickly kind of the lingo that felony is your highest level charge, misdemeanor is a level below that, and infraction is a level below that. So felony, misdemeanor, infraction. And then prison time could be different than county jail time. So that's kind of the distinction there. So if someone served time in state prison, it's potentially not eligible, but county jail is okay. And usually your clients know where they did their time. You can ask them, you know, if they got state time on it or county time, and they know the answer to that. Okay, and then I mentioned there that some convictions are statutorily not eligible. So some sex offenses involving minors, really obscure ones like failure to stop and submit to inspection of equipment, or for creating an unsafe condition endangering a person, which is vehicle code. Those are just like laid out in the statute. You can't apply regardless of what the sentence was. Juvenile adjudications are not considered convictions, so you can't expunge them through 1203-4. There's a different sealing process, but there's already a lot of protections surrounding juvenile convictions, and there's not a lot of instances in which someone would have access to that. So federal convictions have their own really, really limited expungement relief. So unfortunately, they're not eligible for expungement under state. You would have to look to their federal eligibility. And then out-of-state convictions, they must contact attorney in state of conviction. So expungement relief is state-specific. So you're going to have to apply for relief in the state you were convicted in. And each state kind of has their own relief mechanisms. Some are better than California's, but a lot are worse. So you kind of have to check on what's available in that state. This is just a quick overview of the types of expungements and reductions, and I'm going to go into more depth in all of these, but I just wanted to lay it out for you so you could kind of see them all here. And yeah, I'm kind of going to throw a lot of code at you really quickly, and just hopefully not too overwhelmed. You don't need to memorize all these things because maybe we have some time. We'll look at the court forms, and the CR 180, the Judicial Council form, has it all laid out there, and it has all the language there. So if you're ever feeling lost, I always just kind of refer folks to the forms. Just kind of read through the court forms, and then you can kind of figure out where you need to be. But yeah, the 12034 is kind of the big expungement code, and everything kind of falls under there depending on what the conviction was, what kind of sentence they got. And then we can go over some of the felony and misdemeanor reductions under the 17 codes, and also Prop 47 and Prop 64. Okay, so the first one, and kind of, yeah, definitely the most common code where conviction is going to be eligible under is Penal Code 12034. So again, like I mentioned, for all your penal codes, your 12034s, you're going to have to do that two-part process. So the client needs to be eligible first. They can't be serving sentence for any offense. And then you're going to go into the conviction eligibility. In a way that a conviction would be eligible for expungement under Penal Code 12034 was if it was a felony or misdemeanor, and the folks were granted a sentence of probation. And then for expungement petitions, there's this distinction between whether it's mandatory or discretionary. And if a petition is mandatory, it's exactly that. You just file it. The court by law has to grant it. It doesn't always work like that, which is why it's helpful sometimes to have legal representation. But yeah, a way a petition under 12034 would be mandatory is if the client successfully completed terms of their probation. So they didn't have any probation violations. They took all the classes they were required to take. They didn't pick up another case while they were on probation for this case. If they did all those things, they are eligible to file for expungement under 12034, and it's mandatory. The court has to grant it. And kind of The other side of that coin is a discretionary petition where the client didn't successfully complete terms of probation, but then the court can grant the relief in the interest of justice. So if there were some issues with probation under 12034, they maybe didn't take all the classes or they missed court dates and the court revoked their probation, et cetera, it's going to be a discretionary petition. And you're going to be checking a different box, and then you're going to be writing a declaration with the client. And I'm going to go over that in more detail coming up. So 12034, for those felonies or misdemeanors where probation was granted, and then it's mandatory if they successfully completed probation, discretionary if they did not. This is just kind of clarifying that probation can look a lot of different ways and can feel a lot of different ways to a client. So sometimes they don't always know what kind of sentence they got, particularly if they're given something called summary probation, which is also known as informal probation, which is kind of just like a stay out of trouble thing where they're just kind of read their rights and stay out of trouble for 3 years and then you're good. So they don't have like a PO or anybody they're checking in with. They're not really required to do a whole lot. That's kind of where a client may not know they were on probation actually, but that's summary probation. And then formal probation, which is more likely for felony convictions, has kind of the things I think people think about when they think about probation. So like a PO, an officer they're checking in with, court dates they need to make, they need to go through status updates and things like that. So probation is either of those, either it's summary or formal. It doesn't really matter for purposes of Penal Code 12034. Also something to note is it can include any of those things. So if you see probation and jail time, maybe, you know, like 30 days county or a year county, and then they get probation after that, that's still under 12034. They can have probation and fines and fees. They can have probation and community service restitution. But really what you're looking for is if you see probation, you're thinking 1203.4. And maybe the next most common one to 12034 is 12034A. So again, the client eligibility is going to be the same. They can't be currently on probation or parole or serving sentence or charged with any new offense. But the offense level is a misdemeanor and infraction, and the sentence is county jail or a fine. So this is a case where you don't see probation, whether it's informal or formal. There's no probation given. You'll see these for kind of like smaller offenses, maybe vehicle code stuff, where they'll give them, you know, serve 30 days in county and then you're done, or, you know, pay $500 and then you're done. So if you see an offense that's a misdemeanor and infraction and it was given a sentence other than probation, you're going to be looking for eligibility under 12034A. And then the distinction between mandatory and discretionary is obviously a little bit different because you're not looking to whether they completed the terms of probation because they didn't have any. But really what you have is a case that came out that said the language in the code reads has lived an honest and upright life since the pronouncement of judgment. But the court case said that's not like an indefinite thing. It's talking about a year following the conviction. So if the client had no new convictions in the year immediately following the entry of judgment on their case, it's going to be a mandatory petition. You're just checking some boxes, you're filing it. The judge has to grant it. But if the circumstances show that they picked up a case within that following year, it's going to fall into that discretionary box, and you're going to be doing a declaration with the client explaining why the court should use its discretion to grant this petition in the interest of justice. You can read that. 12034.1 it is fairly common. This came out of a Voter Realignment Act in AB 109, which was passed in October of 2011. And basically what happened is the state of California got sued due to prison overcrowding. So they passed this initiative, which allowed folks who traditionally would have done their time in state prison to do their time in county jail. So there's a list of AB 109 offenses, and they call them the non-serious, non-violent, non-sexual offenses that are just deemed not that troublesome. You can go ahead and do your time in county jail as opposed to state prison, and then it's going to be eligible for expungement, right? Because there's not a prison sentence anymore. So usually you'll see the language in the mid-order of the rap sheet. The client was sentenced pursuant to 1170H. That's the code for AB 109. And then there's a distinction here between a straight jail sentence or split sentence. So a straight jail is exactly what it sounds like. The client was given 2 years county time, just a straight jail sentence, or a split sentence. Maybe they got 2 years county, 3 years probation, or a year county, 3 years probation. That would be a split sentence. And that's helpful. We'll go into that, why, because there's a little bit of a waiting period you might have under this one. Oops. Okay, again, like all of them, you have to have the eligible client. And then for a conviction to be eligible under 120341, it has to be one of these AB 109 felony convictions. They had to have been given a county jail sentence. And then there's potentially a wait period here. So if they were given one of those straight jail sentences where I was talking about, they have a 2-year wait period. And if they were given a split sentence, so if they're given county time and probation, they have a 1-year wait period. And dismissal for these is always discretionary. So there's no mandatory expungement under 120341. And then kind of the sister code to 120341 is 120342, which came into effect a couple years ago, but it's a result of a due process issue with AB 109, right? So it wasn't fair that individuals who were sentenced after 2011 all of a sudden were getting to do their time in county and therefore eligible for expungement relief, but individuals sentenced for the same crime in 2009 got a prison sentence and therefore were not eligible to expunge their convictions. So 120342 allows those individuals to go back and have their cases expunged if it's one of those cases that would have been eligible for AB 109 had AB 109 been around when they were sentenced in 2011. So I know the big red flag, right, was prison time, but if you have a prison case that falls under these circumstances, is potentially eligible for expungement relief under 120342. So again, the client eligibility is the same, not currently serving sentence. And then the conviction eligibility, it must have occurred before. It's actually October 2011, because that's when AB 109 went into offense. It has to be one of those non-violent, non-serious felony convictions that's listed under AB 109. They originally sentenced to prison, and 2 years has elapsed since the completion of the prison sentence. So yeah, if you see a prison sentence, but then you look at the date of conviction and it's October 2007, the next step would be to check that AB 109 list and see if the code they were convicted for was on that list, because then it's going to be eligible for expungement under 120342, even though they serve time in state prison. And just like 120341, petitions under 12342 are always going to be discretionary. Okay, 12343, I mentioned really quickly that there were limited circumstances that expungements could be beneficial for immigration purposes. This one's not super common, so I'll move really quickly through it, but this came about because folks were entering into a deferred entry of judgment program, so kind of a plea diversion program, and being told if they completed it, it was going to be not count as a conviction at all, but the feds were still considering a conviction for immigration purposes. So 120343 allows you to go back in and have it removed completely so that it doesn't trigger any federal immigration consequences. It has the same client eligibility. For the conviction eligibility, right, it has to have the specific code for the specific deferred entry of judgment program that they completed. 120349, not super common, but it's a special form of relief for individuals who had a conviction as a result of being a victim of human trafficking. So if you see a conviction for prostitution or solicitation, you might be looking for relief under 12349. You do have a burden of showing by clear and convincing evidence that the conviction was a result of the status as a victim of human trafficking. So you're going to need a declaration for this one, and you might just kind of explain the circumstances surrounding what was going on in the client's life at that time, and that should be enough to prove that clear and convincing evidence burden. Okay, and I already went over but we'll just kind of revisit it really. The distinction between mandatory and discretionary. So again, under 1234, they fulfill the conditions of the probation for the entire period of probation, or they were discharged early due to petitioning the court for early termination of probation. And you should note that that's different than the court terminating their probation because maybe they picked up another case or something like that. This is actually requires petitioning the court because of good behavior to terminate the probation early, and then the court granting that. That would make that a mandatory expungement petition after the fact. And then under 1234A, I talked about has since pronounced of judgment, lived an honest and upright life and conformed to and obeyed the laws of the land. And again, that's just for the year following the conviction. So if they're able to stay out of trouble for that following year, the petition under 1234A becomes mandatory. And then the discretionary ones, right, under 1234, any revocation or violation of probation, kind of a big one. You'll see folks who kind of going through a rough time, so they might pick up a number of convictions back to back. So if they're on probation for a case and they picked up another case, that would likely be a violation of probation, and it would become a discretionary petition. And then under 1234A is if they picked up an offense within that following year. And just to note, that means that there is a 1-year wait period under 1234A if you can't file before that year is up. And the distinction is important because for those discretionary petitions, you're going to be writing a declaration with the client. And this is because the court, right, is trying to decide if this person is sufficiently rehabilitated enough to warrant this type of relief. So we're going to go over a couple of examples really quick, but I think it's helpful to keep the declaration in your head in these 3 parts. So the first part, you're going to go over the circumstances of the offense. And this can be just really brief, right? It's not really a time to relitigate the offense, or you don't have to go in super detail. Just, at the time of my life, I was, struggling with addiction or just kind of get in and out with this, and then move into kind of the improvements they've had since the offense. So whether they went back to school or were volunteering or going to church or taking care of family or working, whatever it may be, any classes that they took, even if they were court orders, so AA or NA or anger management or parenting classes or anything like that, you can talk about where the client has come from since the time they got the conviction, and then kind of wrap it up with the current need for expungement. So why the petitioner is asking the court for this type of relief. And that can be as simple as I'm just looking to move forward with my life, or it can be more specific, right? Like I'm applying for this job and they won't hire me with this conviction. I'm looking to find more substantial gainful employment so I can better provide for myself and my family, etc. And then what we'll encourage clients to do is include supporting documents with these discretionary petitions. So I mentioned earlier, sobriety certificates, diplomas, character references, anyone they think that can speak to where they were before and where they've come now can be compelling. So and I kind of treat it like the kitchen sink. You just throw everything in there. The more the merrier. Anything you can throw in there that can kind of help substantiate or back up maybe some things you were saying in the declaration can be really helpful. And in our clinic setting, sometimes clients don't always have these. We'll sometimes encourage them to bring them beforehand, but they can always make copies and bring them to the hearing if that's the case. And it's been helpful. I've been in court before where the DA has objected and the judge has kind of gone through all the supporting documents and asked the DA if he took a look at those and then, granted it over the DA's objection. So if you have supporting documents, that's potentially pretty helpful. The slide is just kind of about working with clients, particularly when you're going to be writing a declaration. It's important to maintain sensitivity because the things you're talking about are potentially kind of sensitive or uncomfortable or painful. So things that could come up would be financial struggles or abuse or drug and alcohol use, homelessness or childhood adversity. So yeah, just kind of remember to meet clients where they're at and acknowledge that, yeah, you're aware that probably some of this stuff isn't fun for them and some can be like pulling teeth. So And here's an example of a bad declaration. Obviously, check your spelling. This box here in the middle, this was not my fault. This comes up occasionally, but can potentially be really difficult to deal with because the court already considers it as a guilty plea, right? They've already been adjudicated. It's not really the place to relitigate the offense. Really what the court is looking for is kind of some statements of responsibility and ownership and remorse, which can be tough, right? If the client is in a position that, you know, maybe they were railroaded or it didn't really happen like the court thought it happened type thing. So that can be a little bit tough to get around. I think something you could do potentially that'd be helpful is maybe pivot it into, like, you know, if a client is comfortable saying, talking about maybe things they would have done differently if they could go back and do it, right? So they wouldn't have put themselves in that position or would have been hanging around that crowd or something like that, where you don't really have to go directly in a conviction, but you can kind of talk about something the client learned or an understanding they've had since then. Bringing up other cases unnecessarily. The court's going to have the DOJ rap sheet there, so they're going to see the person's conviction history, but unless it's really necessary, it doesn't really make sense to talk about a bunch of other cases in a declaration that you're filing for this petition. Sometimes you could kind of frame it like, particularly if all the convictions happened within a short period, right, that I was struggling at this point in my life due to yada, yada, yada. So I had some law enforcement interaction, that type of thing. But other than that, it doesn't really make sense to talk about other cases a whole lot in there. And then, yeah, holding me back, I need my case expunged. You should go into more detail about why they need the case expunged, right? Like why they're looking to get it cleared off the record. How is it holding them back, right? What is it? They've applied for jobs and been denied, etc. And here's an example of a good declaration. So again, I mentioned, right, this came from a very difficult time in my life. Talk about a mental state or homelessness, you can kind of paint the picture to the court that, yeah, this person was experiencing quite a bit when they picked up this conviction, and then kind of move into why they're no longer in that position, right? So they worked very hard, been sober, own their own apartment, returned to school, and then kind of what they're planning to do with that. And again, to have supporting documents, so like working toward getting my GED at LA Trade Tech, if we could throw in transcripts or sobriety documents. They talk about being sober since 2017. Anything you can kind of throw in there helps increase the odds of the expungement getting granted. And then, yeah, just a better job here of going into what the expungement would mean for them. So continue to pursue my career goals, be more self-supportive, productive member in community, etc. So instead of just, I need this granted, why you need this granted. How are we doing on time? Okay. I think we have time. I'll move kind of quickly through these. These are kind of expungement adjacent forms of relief. And I mentioned earlier, you have your 3 levels of convictions, right? Your felonies, your misdemeanors and infractions. These are the reduction mechanisms. So these are things you could file to reduce felonies to misdemeanors and misdemeanors to infractions. 17B you can do right on the expungement petition. It's on the CR 180 right next to the expungement codes. And this allows the client to petition the court to reduce a felony to a misdemeanor in the cases where the charge is what's called a wobbler. And a wobbler is an offense that could be charged as a felony or a misdemeanor, but the DA used their discretion to, for whatever reason, to go forward with it as a felony. If they did everything they're supposed to, the court decided they wanted to, you could file under 17B and they could reduce it after the fact from a felony to a misdemeanor. And this is always discretionary, so you're always going to want a declaration and hopefully some strong supporting documents. And then, yeah, next to the 17B is the 17D2. And this is where you can petition for reduction for what are called wobblets. And if wobblers are felonies to misdemeanors, wobblets are misdemeanors or infractions. So again, it has that, the court has that, or the DA had that discretion. It has the language to be sentenced as either a misdemeanor or infraction, and they went forward with a misdemeanor. you could petition after the fact to have it reduced to an infraction under 17D2. Always discretionary as well. And then Prop 47. So Prop 47 reclassified several non-serious, non-violent offenses from felonies to misdemeanors. It passed in 2014. It made it so that what were previously felonies were going to be misdemeanors going forward. A lot of them were wobblers, and the decision was made that too many were being charged as felonies, so kind of took that discretion away. They're going to be misdemeanors for all purposes going forward, and it had this retroactive component that allowed folks who were sentenced to these convictions prior to 2014 to go back and have their felonies reduced to misdemeanors if they're eligible. So it's similar to the 17B reduction, but it has this carved out where it doesn't restore your gun rights. So in California, if you have a felony conviction, you lose your ability to own guns. Having your felony reduced under 17B would restore those gun rights. Having reduced under Prop 47 would not. So the benefits are similar to expungement. It can help with employment. Obviously, a misdemeanor is less scary sounding than a felony. And then kind of in these circumstances, it can lead to expungement. So you could have had a felony, a case that was sentenced as a felony where they did state prison time, and then you Prop 47 reduced it to a misdemeanor, and then it's eligible for expungement because it's a misdemeanor sentence without probation at that point. So again, if you see prison, another thing you might be looking for is it a Prop 47 eligible offense? So Prop 47, the eligible offenses are simple drug possession. So the health and safety codes 11350, 11357, 11377. And then low-level property theft crimes, so shoplifting, forgery, writing bad checks, theft, petty theft of the prior, receipt of stolen property. If you see any of those codes, those are all misdemeanors going forward. One thing to add with the theft crime, though, the amount of the property has to be less than $950 to qualify. So if it's more than $950, it's still a felony. You can't ask for it to be reduced. But you know, if it was shoplifting for some diapers from Walmart in 2010, that might have been a felony. So someone could petition at this point to go back and have that reduced under Prop 47 to a misdemeanor. One thing to note for Prop 47 is you could have a conviction history that would make you ineligible to apply for Prop 47 on any case. So if you had a conviction for a case that required you to register as a sex offender, or you had any of these super priors previously, then you wouldn't be eligible for Prop 47 on any other case. So you might need to take a look at the rest of the client's rap sheet just to make sure they don't have any of these before you apply for relief under Prop 47. Prop 64 was the Adult Use of Marijuana Act. So what that did, right, it decriminalizes and reduced most felony and misdemeanor penalties for marijuana offenses, right? This was the Marijuana Legalization Act. And it also had this retroactive component, right, that I think was maybe deliberately not talked about as much, that allowed folks to go back, just like Prop 47, and if they had a conviction that either changed the status from felony to misdemeanor or was no longer illegal, like simple possession of marijuana, they could file with the courts to have it either reduced or dismissed completely. So again, it's a retroactive form of relief for folks that had convictions for things that were either no longer legal or not a serious offense. Okay, how are we doing on time? 15 minutes. Okay, so reading a criminal docket and rap sheet. These are what the clients are going to bring in, where you're going to review and take out the pertinent information to fill out the forms and figure out what kind of relief they're going to be eligible for. So the two kind of big ones are dockets or minute orders, or the same things, and a rap sheet. So first we'll go over the docket, which I think an important thing to keep in mind is the case number in the top left corner, just because that helps keep everything in order. So just always check the top left corner, make sure you're dealing with the same case. And minute orders will have every court appearance on there. So it has just kind of a lot of superfluous information that you don't need. So it's more about just kind of weeding through and pulling out the stuff you really do need. So you have your case number up there in red, the defendant's name, the arresting agency becomes important for who you're figuring out who you need to provide proof of service to. And then you have the initial charges there. And those are important to note, but just know that lots of times the initial charges will change throughout the proceedings. So, and that could be because different facts come out, or the client accepts a plea deal, right, to another charge. So just kind of note the initial charges and move on. Because really what you're looking for is the disposition. So if you kind of go halfway down that page, you see count 3, dispo convicted, and then you say, wait a second, there was only 2 counts, so you go up a little bit, and then you see they added this count 3 here, this vehicle code violation, and they dismissed the other 2 counts. So it looks like the client probably took a plea deal to another charge. Disposition was convicted of this count 3 of this vehicle code 23103. And then kind of the most important thing you're looking for is what kind of sentence they got, right? Because then you're going to know if they're eligible, and what in fact they're going to be eligible for. So you scroll down a little bit and you see the defendant was placed on summary probation. So again, that's that informal probation, but it doesn't really matter. You see probation, you should be thinking 12034, right? That's kind of the big one, sentence with probation. And then the next thing you'd be looking for to figure out whether it was going to be a mandatory or discretionary is if they did everything they were supposed to do on probation. So looks like if we keep going, you're going to see, right, that probation was revoked and reinstated. So when you look up a little bit, they issued a bench warrant at some point. So looks like maybe they missed a court date or something like that. They issued a bench warrant, revoked their probation, and then reinstated it. And then you know you're going to have to do a declaration because this is in fact going to be a discretionary petition. The next thing clients will bring in that have their court information are their DOJ rap sheets. And these don't have every court entrance in them, but they can kind of bleed together. So I think it's really helpful to keep in mind that the 4 stars signify the same case. So until you see 4 more stars, you know you're still in the same case. The 4 dashes or it could be another court appearance or another update on that case. So you see the 4 stars at the top. You look down a little bit, about a third of the way down the page, you see the case number there, that TA 12345. Scroll down a little bit, and you're looking for disposition, right? So dispo convicted. Looks like they were convicted of 11377A, which is possession of a controlled substance. TOC is the type of charge, and it's a felony. And then you're looking for what they were sentenced, right? So they're given 3 years probation and 30 years jail. So doesn't look like any prison time. So it looks like they're going to be eligible for expungement under 12034 because there's a probation given. This is also a Prop 47 eligible offense, I'm pretty sure, and 17B. So you could reduce it as well. And then one thing DOJ rap sheets won't have is how they did on probation. So you'll have to kind of check in with the client to see, you know, did they remember being back in court? Did they do everything they were supposed to do? Because that's how you're going to make that distinction between mandatory and discretionary. Forms and filings. So I mentioned it, but the Judicial Council has forms for all of these. The CR 180 is actual petition. The 181 is order for dismissal. We file fee waivers with our clients because all our clients qualify. LA County charges $120 per petition for cases with probation and $60 for cases without. So we file all the fee waivers and kind of let them sort that out. The declaration you're going to be writing on the MC31 form, and then proof of service. And I hope these are all in the materials that were shared with everyone. If they're not, let us know and we can send those out. Prop 47, Prop 64, really simple. They're just either 1 or 2 pages. You're just checking boxes if they apply, and you're good to go. There's no discretionary, mandatory, anything like that. If they're eligible, they get granted. Some frequently asked questions, and again, this might change when I go to the COVID slides next, but clients usually want to know how long the expungement process takes. And kind of on the shorter end would be 6 weeks, but it can take up to 3 months depending on the courthouse you're filing at. Do I have to appear in court? Does LAFLA appear for me? Some courts hold hearings on expungements, not all of them. Some of them will just do them in chambers. If they're holding a hearing, they're supposed to let you know. And we usually advise folks to go if they can, just because it helps kind of put a face on the petition. If anything goes wrong, somebody's there and they can ask questions or figure out what they need to do differently. We don't typically attend with folks unless we can. So we'll tell them, you know, if it makes sense, if it seems like it's a particularly difficult case, we'll make the effort to be there, but usually it's on the clients to show up. Filing fee, we already went over that. We filed the fee waivers. Check on status of the case. You can call the courthouse or get online and see if, put in your case number and see if they put an update there about a hearing date. How long will it take for my background check to update? So it usually takes about 30 days for private background checks to update, and then it can take up to 6 months for DOJ to update your rap sheet. So just kind of keep that in mind if you're applying for jobs, and be prepared to maybe show proof of the expungement if necessary, or explain it to a potential employer. What happens if my case is denied? You can always refile a case. We usually advise folks to give it some time, just because I think judges can get annoyed if you're filing every week, but 6 months seems to be a decent waiting period. Keep doing well, maybe add to your declaration, get some more supporting documents, and then refile. Or usually what tends to happen is client has multiple cases, you file on all of them at the same time, maybe 1 or 2 get denied, and then you can come back on those 2 at the end and add to the court that, look, everything else has been expunged. These are the last things on my record. These are the last things holding me up, type thing. Is there a limit to refiling a case? There's no limit. A judge can deny a case with prejudice. It has happened. Doesn't really make sense, but it has happened. So again, you might want to give it a little bit of waiting time before you refile. Okay, so some of the ways this has changed, the way we've kind of adjusted to working under COVID-19 is court closures have kind of made it difficult for folks to get their minute orders. We've been working with a way to obtain dockets from court clerks, but it really depends on the courthouse and the clerk and probably how they're feeling that day, because sometimes those requests go ignored. Some counties you can get online and pay a small fee. LA you pay $1. You can access their online database. The DOJ, so the live scan, the fingerprinting, were declared an essential critical infrastructure. So you could advise a client to go down and do their live scan if they felt comfortable doing that. And there's a DOJ website has a map where you can kind of put in your address and figure out which one is closest to you. Courts in LA County aren't holding expungement hearings at the moment, so they're being set for late June, early July. I think there's going to be a push for more remote hearing capabilities, and there is some policy coming through that is looking to potentially do mandatory, just to automatically grant mandatory expungement. So some of the counties have kind of already taken on that onus. San Francisco dismissed all their old marijuana convictions without folks having to file. So, and LA has kind of indicated that they're open to moving that way as well. Barriers dealing with clients, right? The intake onboarding process becomes a little bit difficult because some of our clients don't have access to things like scanners or fax machines. So it's hard to obtain documents or exchange documents. We've been utilizing DocuSign for client signatures where necessary. And we've still been operating a virtual clinic, which I think functioned pretty well last month, and I think we're doing it again this month. But again, sometimes clients don't always have the necessary tech or internet access for that. So just some things to consider. I think that's it. We have five minutes for question. I know that was a lot of info, and I talked really quickly. So I don't know if there's any questions or there's anything we need to go over, but yeah, I appreciate you all being here. Again, yeah, let me know if anything comes up, have any questions.
Yeah, so I'm going to read off the MCLE code really quickly for everyone who's on Zoom or on the phone. So the MCLE code is 2951060. Again, 2951060. And you can send your completed MCLE form to Tia Wood by Friday, May 5th. And Gio, it looks like we have one question. The question that we received is, what are experiences of clients these days? I'm guessing in the context of expungement.
Experience with clients.
Yeah, do they still need help?
Oh, yes, they still need help. And I think, That's fine. Asking questions. Yeah. Yeah. They still definitely need help, and kind of more important now than ever, particularly when we talk about those employment considerations, right? I don't know if everybody's aware, but we have record numbers of folks filing for unemployment, potentially going into recession, and you have some of our most vulnerable populations that have these additional barriers that are going to make it harder for them to get a job. So a lot of people who've been looking for work now are still facing those same barriers about having a conviction history, and that's going to become even more important moving forward, just so you're not leaving this whole group of people behind. So yes, they still need help. A lot of them are sheltering in place again, so that's why we're utilizing tech where we can for those virtual clinics and DocuSign and things like that. But yeah, a lot of clients want to be out working, like doing things for Uber or DoorDash, or taking advantage of some of those areas that are hiring, and their record is creating an issue. So expungements are still extremely helpful. Do we file out of county cases? Yes, we do. Each county is a little bit different. So it's important to kind of check the court website and their local rules to figure out what you need to do. Like Sacramento, you have to file 5 copies and serve 3 different agencies. So you just want to make sure that you're up to date on the court rules before you file in that county.
Yeah, I had a question, Gio. For people who haven't done an expungement clinic before, would you mind just going over what they could expect when they volunteer at a clinic and what that process is like, especially if they're unsure about all of the law that we just went over?
Yeah, so our clinics, and this is true even for the virtual one now, all our clients are pre-screened, so a lot of the initial legwork is already done for folks, and they might get a petition that just needs a declaration or needs to be finished in other ways, and they'll have access to a LAFLA attorney. If they have any questions or anything comes up, we'll either be online with them on Zoom, or right, if it's in person, we're always there at the kind of roaming around at the clinics answering any questions. Where we can, we usually pair folks, because we found that that's helpful to have like an attorney partner to kind of bounce ideas off, just to make sure you're moving in the right direction. So we've noticed that's helpful. But by and large, I don't know, you can correct me, it's not super stressful. Clients are usually extremely grateful. They're excited to have somebody in their corner. They're not usually used to that. So they may have questions for you about what kind of work you do at Latham, but they're usually pretty stoked to be there. They're excited. They're kind of meeting them at a point in their life where they're transitioning, right? They're moving forward. They may have had some struggles in the past, but they're doing really well and looking to keep improving. So it's really inspiring, and people are, like I said, are always pretty grateful for the help.
Yeah, I think one of my favorite things about expungements is that, even transactional attorneys or people who don't usually do this kind of law can easily help people. You can fill out a form and just be done with helping someone expunging a conviction in like an hour or 2. So yeah, really, really helpful. One thing that we wanted to do before we ended was plug additional pro bono trainings, which are available on pbtraining.org. I know that there's an expungement training that a lot of Latham folks have done. And it's kind of similar to this one, but maybe more in depth, and it's broken up by modules. So in case you wanted to go back over a certain section, you can do that. And yeah, I don't think we have any other questions. So yeah, Gio, thank you so much for being with us and for doing this training. We really appreciate it. We finished in record time, so thank you very much.
Yeah, I was happy to get in under an hour because it's a lot of info. So hopefully the materials will be helpful. And like I said, if you have any questions, just feel free to reach out. And yeah, we appreciate our partnership with Latham and Watkins, and appreciate you, Ashley, for all your work on this.
Yeah, thank you so much, everyone, for joining. Have a good one and stay safe. Bye.